All right, so last we looked at the First Amendment's religion clauses, which are the establishment and the free exercise, and how the courts kind of still struggle with the relationship between government and religion. Today, we're going to turn our attention to another part of the First Amendment, which is the freedom of speech. And this is a very rich and dynamic area of constitutional law, and it's often at the forefront of public debate and individual rights. Now, let's begin as always with the text. The First Amendment states Congress shall make no law abridging the freedom of speech or of the press. Okay. And note that the press is often understood as a specific form of speech. And the core purpose of this clause is to protect a public discourse, individual expression. Okay. It's not just about political speech, although that is certainly a very central component, especially these days, but it's about ensuring this vibrant exchange of free ideas in a free society. Okay. And just as a reminder from the last lecture, where it said, or not from the last lecture, it would have been the one from before, right before, where it said, Congress shall make no law. Through the process of the incorporation via the 14th Amendment's Due Process Clause, those protections against federal action have been extended to apply to the state and local governments as well. So again, when we discuss these cases, remember, we're looking at what both federal, state, and local governments can and cannot do in regards to speech. So before we get into the complexities of what speech is protected and how, it is worth taking a moment to consider why we protect speech so strongly in the United States, okay? What are the core rationales that underpin this fundamental freedom? And the Supreme Court and the legal scholars have articulated that there are several key justifications. And first is the marketplace of ideas. And this is one of the most enduring rationales that was famously articulated by philosopher John Stuart Mill. And it was embraced by American jurists like Justice Oliver Wendell Holmes. And the theory posits that the best way to determine truth is through open and robust debate. So if all ideas, even those that we find abhorrent, are allowed to compete freely in the marketplace, then truth will ultimately prevail and false ideas will be exposed. It also allows for the correction of error, our own or that of others. And so the idea is that censorship, even of bad ideas, prevents society from truly testing and refining its understanding of the world. Next is self-governance and democratic participation. So for democracy to function effectively, its citizens must be informed and capable of participating in public discourse. And free speech is essential for an informed citizenry to criticize the government, to discuss policy, to advocate for change, right? It allows citizens to hold their elected officials accountable and to shape the direction of their society. And without the freedom to express political views, then a democracy can hardly be said to exist. Next is the individual autonomy and self-fulfillment. So beyond the societal benefits, free speech is seen as a fundamental aspect of human dignity and self-realization. So the ability to express one's thoughts, their beliefs, their identity, it's all integral to what it means to be a free individual. So the rationale emphasizes the speaker's right to express themselves, irrespective of the message's impact on public discourse. It is simply about the inherent value of the individual expression itself. And finally is the safety valve. And this rationale suggests that allowing people to express their grievances freely, even if those expressions are unpopular or controversial, it can prevent more dangerous outlets for discontent. Okay? It allows for the peaceful release of tensions and frustrations, or it should be peaceful release of tensions and frustrations. It's supposed to reduce the likelihood that suppressed anger is going to erupt in some sort of violence or instability. But these rationales often overlap and reinforce each other. And they highlight that free speech is not just a nice to have thing, but it's a fundamental pillar of American society and its democratic ideals. Now, how does the court even decide if a government regulation of speech is constitutional? The first and the most critical step in the First Amendment analysis is to determine whether the government's regulation is content based or content neutral. Okay. This distinction dictates the level of judicial scrutiny that gets applied. Okay. And thus, the likelihood of the law being upheld. So, a content based regulation is going to restrict speech based on its message, its subject matter, its viewpoint. So, for example, a law that bans protest against a certain policy but allows protest for it is content based viewpoint discrimination. Okay. Or you might have a law that prohibits all political speech but allows commercial advertising. That is content based subject matter discrimination. So, because content based restrictions strike at the very heart of the marketplace of ideas and democratic participation, they trigger strict scrutiny. And that is the highest level of judicial review. And that is a huge, huge hurdle for the government to overcome. So, to survive strict scrutiny, the government has to prove two things. First, it has a compelling government interest for enacting this regulation. This interest must be extremely important, not just merely legitimate or substantial. Okay, so examples would be like national security or public safety or protecting the integrity of the electoral process. Okay. The second thing is that the regulation must be narrowly tailored to achieve that compelling interest, and it has to use the least restrictive means possible. This means that the law cannot be overbroad, it cannot be restricting more speech than necessary, and there shouldn't be a less burdensome way to achieve the government's goal. Okay? So, because this standard is so difficult to meet, content-based regulations are presumed unconstitutional and they're rarely upheld unless they fall into one of the narrow categories of unprotected speech that we'll discuss next. Now, in contrast, is content neutral regulations, and these restrict speech without regard to its message. So these regulations typically focus on the time, the place, and the manner of speech. So, for example, a law that prohibits all amplified sound in a residential neighborhood after 10 p.m. is content neutral because it applies equally to a political rally, a religious sermon, or a rock concert. Like, it doesn't care about the message, it just cares about the noise that's created. So because these regulations do not target the message itself, they trigger a lower level of review, and that is the intermediate scrutiny. To survive intermediate scrutiny, the government has to show, first, that it has a significant government interest. This is a lower bar than compelling, but still it requires a real and important interest like traffic flow, public safety, or preventing excessive noise, okay? And second, the regulation must be narrowly tailored to serve that interest. That means that it shouldn't be substantially overbroad, but it doesn't necessarily have to be the least restrictive means, okay? The fit between the regulation and the interest itself just needs to be reasonable, okay? And then you have the regulation must leave open some sort of ample alternative channel for communication. So people still need ways to get their message out, even if the preferred time, place, and manner is restricted. So content neutral regulations are generally permissible if they meet that test because they are seen as regulating the non-communicative aspects of speech. And it's a critical distinction that you have to grasp. Now, while the First Amendment protects a wide range of expression, it is crucial to understand that not all speech is protected equally. So the Supreme Court has, over time, identified certain narrow categories of speech that either receive less First Amendment protection or, in some cases, receive no First Amendment protection at all. And that means that the government can regulate or even prohibit these types of speech with far less constitutional justification than it would need for fully protected speech, and often without triggering any kind of strict scrutiny in the process. And the rationale for these exceptions is that these categories of speech are generally deemed to have little or no value in the marketplace, or the marketplace of ideas, rather, or they are directly linked to specific substantial harms that the government has a clear right to prevent. For example, a true threat of violence doesn't contribute to public discourse, it instills fear, right? Fraud, it doesn't promote truth, it causes economic harm. So, the consequence is that when speech falls into one of these categories, the government has a lot more leeway to regulate it or prohibit it. So, we're going to examine the most significant categories of this, but just know that this is a includes but is not limited to type situation. Let's start with speech that incites violence or constitutes fighting words. The court has struggled with the line between advocating for change, which is protected, and urging immediate unlawful action, which is unprotected. So we have the incitement to violence. And this category deals with speech that encourages others to break the law, particularly through violence. And the early test for such speech was the clear and present danger test that came from the case of Schenck versus the United States. Now, Charles Schenck was the general secretary of the Socialist Party, and he had distributed these leaflets to men who had been drafted into the armed forces during World War I. And these leaflets argued that the draft constituted involuntary servitude. Thus, it was violating the 13th Amendment. And it urged men to assert their rights and to petition for repeal of the Conscription Act. But it did not explicitly urge them to resist the draft or to commit violence. So Schenck was charged with violating the Espionage Act of 1917, which prohibited causing or attempting to cause insubordination in the military. So the issue before the court was, did Schenck's conviction for distributing leaflets urging resistance to the draft violate his First Amendment right to the freedom of speech? And the Supreme Court unanimously upheld the conviction. They found that his speech was not protected by the First Amendment. So Justice Oliver Wendell Holmes wrote for the majority, and he very famously articulated this clear and present danger test. And he wrote that the question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. And he provided the analogy that the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing panic. So in the context of wartime, with the nation, needing to raise an army, the leaflets, though subtle, could, in the court's view, have affected negatively or been an obstruction of the draft, basically. Thus, it was posing a clear and present danger to national security. So the court emphasized that speech that was tolerable during peacetime might not be tolerable in wartime. And so the clear and present danger test, it was the first significant attempt to define when speech could be restricted based on its potential for harm. So I will add, though, that it was very broad. It was a subjective test, and it led to the suppression of a great deal of political speech, especially during times of perceived national emergency. And it was often criticized for not actually providing enough protection for dissent. But the clear and present danger test was eventually replaced by a much more protective standard, and that was in Brandenburg versus Ohio, which remains the current test for incitement to violence. So Clarence Brandenburg was a KKK leader, and he organized a Klan rally in a field. And at the rally, he was recorded by a local television station. And Brandenburg made some inflammatory racist and anti Semitic statements. He was advocating for revenge against racial minorities and Jews, and he even spoke of the possibility of taking some revengeful action against the president, Congress, and the Supreme Court. And he was convicted under an Ohio statute that prohibited advocating violence or sabotage to achieve political reform. So the issue was, did Ohio statute, which prohibited, again, advocating violence for political reform, violate Brandenburg's First and 14th Amendments rights to free speech? And the Supreme Court unanimously overturned Brandenburg's conviction. And they found that it did, in fact, violate his First Amendment rights. And in doing so, the court established a new, highly protective test for incitement. So in the opinion, the court held that speech can be prohibited only if it satisfies a two-pronged test. The first is the speech is directed to inciting or producing imminent lawless action, and it is likely to incite or produce such action. So the court found that Brandenburg's speech, while offensive, was not directed at inciting imminent lawless action, nor was it likely to do so. It was merely abstract advocacy of violence, which, under the new test, would be protected. So the Ohio law was now deemed as too broad because it punished mere advocacy rather than incitement to immediate action. So Brandenburg versus Ohio established a very high bar for the government to meet to punish speech as incitement. And it significantly broadened the protection for political speech, even hate speech, as long as it does not immediately lead to illegal action. And it reflects a strong commitment to protecting very strong and even offensive political discourse unless it poses a truly immediate threat of violence. And this is a critical case for understanding the limits of the government and the power to suppress speech. Now, for speech to be considered unprotected incitement, it has to be directed to inciting or producing imminent lawless action and likely to produce such action. For example, let's say that you have a speaker who's at a very tense protest outside of a government building, which there's a lot of that going on right now. And there's an angry crowd already throwing rocks, shouts into a megaphone saying, "Go break down those doors. They can't stop all of us. Do it now." The crowd then immediately surges forward and attempts to breach the building. This speech is directed at inciting imminent or immediate lawless action, which is breaking down the doors. And given the context of the agitated crowd and the immediate follow through, it's likely to produce that action. So this would be considered unprotected incitement. Now, let's say that you have this political pundit on a news show who says our government is tyrannical and eventually the people will have to rise up and use force to reclaim their liberties. All right. So this speech advocates for violence, but it is abstract and it's not directed at inciting imminent lawless action. So there's no immediate call to a specific violent act, nor is it likely to produce such an immediate act. So this would generally be protected under the Brandenburg test. So let's say that you have a frustrated citizen who during a public town hall meeting shouts, "Someone ought to punch that council member in the face for what they just said." Well, is that covered or not? Because this one might be a little more challenging. You have to ask, is it directed at inciting imminent lawless action? This is a spontaneous outburst, but is it likely to incite? If that council member is surrounded by bodyguards and the room is calm, then probably not, okay? If the speaker is a known leader and the crowd is on the verge of violence, then it could be. But the Brandenburg test requires a specific factual analysis of that imminence and that likelihood. Now let's talk about the clear and present danger speech, because this test allowed speech to be restricted if it created a clear and present danger of substantive evils that Congress had the right to prevent. And this test was much more broad and less protective than of speech itself than Brandenburg. So from the Shank, context itself, distributing leaflets to men who have been drafted into the military during wartime, urging them to resist the draft, stating that it's unconstitutional and they should assert their rights. In this particular context of World War I, the Supreme Court deemed that this speech was enough to create a clear and present danger of obstructing the war effort, even if it didn't explicitly call for violence or immediate action. So the potential harm was impeding, military recruitment during wartime, and that was seen as sufficient. Now, let's say that we have a severe, public health crisis, and someone knowingly and falsely shouts in a crowded public square, "The water supply is poisoned. Everybody run for your lives," and it causes a stampede. Well, applying that, Shank logic, this fits perfectly with what Justice Holmes' famous analogy was. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. So this false statement creates an immediate severe public safety danger. So under the Shank test, such speech would clearly meet that clear and present danger threshold because of the direct and immediate harm that it causes. Now, let's say that you have a group who holds a peaceful rally and they discuss their beliefs that the government is corrupt and oppressive and suggesting that citizens might need to take up arms in self-defense at some point in a future unspecified point. So under the Shank test, this kind of speech might have been deemed a clear and present danger because authorities could have been concerned about potential future unrest, as that test was often interpreted broadly. But under Brandenburg, this would generally be considered protected abstract advocacy because it lacks imminence and the likelihood of leading to that immediate lawless action. So this contrast, highlights how Brandenburg it provided significantly more protection for advocacy, even radical advocacy, compared to Shank. Now, fighting words is another narrow category of unprotected speech, and it is designed to apply to face-to-face insults. And the definition of fighting words came from Chaplinsky versus New Hampshire. All right, so in this case, you have Walter Chaplinsky, and he is a Jehovah's Witness who was distributing religious literature, on a public sidewalk in New Hampshire. And a crowd gathered. And Chaplinsky began to verbally abuse a city marshal, calling him, and this is a direct quote, these are not my words, quote, "a goddamn racketeer," and quote, "a damn fascist." And he was arrested and he was convicted under a state law that prohibited addressing any offensive, derisive, or annoying word to any other person who is lawfully in any street or other public place. So the issue was, did Chaplinsky's conviction for using fighting words violate his First Amendment right to freedom of speech? And the Supreme Court unanimously upheld the conviction. They found that his words constituted unprotected fighting words, okay? And Justice Frank Murphy wrote for the majority, and he said that there are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problem. And among these were fighting words, defined as words which by their very utterance inflict injury or tend to incite an immediate breach of the peace. And the court found that Chaplinsky's words, which were uttered face-to-face to a public official, were likely to provoke an immediate violent reaction and thus fell within the unprotected category. And these words, the court said, were, no essential part of any exposition of ideas, and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. So, Chaplinsky versus New York, it created the fighting words doctrine, and it identified a category of speech that receives no First Amendment protection. Now, since Chaplinsky, the Supreme Court has interpreted this category very narrowly, and the court has become increasingly reluctant to uphold laws banning fighting words, simply due to the concerns about vagueness and kind of overbreadth, like fearing that such laws could be used to suppress legitimate, albeit offensive, speech. And cases after Chaplinsky have consistently overturned convictions for this offensive or insulting speech, largely because the words were not delivered face to face, which was, to provoke an immediate breach of peace, or because the statute itself was too broad. And that's why you rarely see fighting words laws being upheld today. But a great example of the limits on the fighting words doctrine and protection for offensive speech comes from Cohen versus California. Now, here's your next trigger warning. Language, there's going to be lots of it in this, but in Cohen versus California, you have Paul Robert Cohen, who wore a jacket to a Los Angeles courthouse and was in the hallway, and it displayed the words, "Fuck the draft, stop the war." And there was no evidence that anyone was provoked to violence by his jacket, though some onlookers might have been offended. So he was arrested. This was in 1942, by the way, so you're still in wartime. And he was arrested and he was convicted under a California statute that prohibited maliciously and willfully disturbing the peace or quiet of any neighborhood or person by offensive conduct. So the question before the court was, did California statute, as applied to his jacket, violate his First and 14th Amendment rights of free speech? And the Supreme Court reversed his conviction. And they found that his speech was protected by the First Amendment, and that the state could not criminalize the display of offensive language in these circumstances. So we have Justice, what's his name? John Marshall Harlan. He wrote for the majority, and he distinguished Cohen's case from Chaplinsky and found that Cohen's words, while offensive to some, were not directed at a specific person and in a manner that would provoke an immediate breach of the peace. And so the jacket was a form of symbolic speech, and the message was not, it was not obscure. Just as Harlan had famously articulated that one man's vulgarity is another's lyric. And he reasoned that allowing the state to ban particular words simply because they are offensive would give the government a dangerous power to censor. And he stressed that while the particular four-letter word, being litigated here is perhaps the most distasteful, even more so than most of it in the genre, is nevertheless not a fighting word. And so the court emphasized the importance of protecting offensive speech as a vital part of the marketplace of ideas. Again, noting that emotive language often conveys ideas very powerfully. And he concluded that absent a more particularized and compelling reason for its actions, the state may not, consistently with the First and 14th Amendments, make the simple public display of this single four-letter expletive a criminal offense. So Cohen versus California strongly reaffirmed the principle that the First Amendment protects offensive or vulgar speech, particularly political speech, unless it falls into a very narrow, unprotected category like incitement or true fighting words. Again, used in a face-to-face provocative manner. Okay? It reinforced the idea that the government cannot act as a custodian of public morality by banning words simply because they are deemed offensive. And this case remains a very powerful precedent for protecting speech that many may actually find disagreeable. Now, another category of speech that receives absolutely no First Amendment protection is obscenity. And we should specify here that the definition of obscenity itself has been a long and challenging journey for the Supreme Court, because what one person finds offensive, another might consider art. And the court's efforts to define it have been difficult, trying to distinguish between constitutionally protected, sexually explicit content and unprotected obscenity. And so the current standard is the Miller test, which comes from Miller versus California. Now, this, just for context, was from, I think, 1973. But Marvin Miller ran a mail order business for adult materials, and he sent out a mass mailing to advertise his sexually explicit books and films. And the advertisements contained explicit images. And several recipients, including a restaurant owner whose mother and son opened the envelope, complained to police. And Miller was convicted under a California obscenity statute. So the question before the court was, what is the constitutional definition of obscenity? And did Miller's conviction for distributing sexually explicit advertising material violate his First Amendment rights? And the Supreme Court upheld the conviction. And they said, they determined there was this new 3-part test for determining what constitutes obscenity. Okay. So Chief Justice Warren Burger wrote for the majority and said the court acknowledged the difficulty of defining obscenity, but stated that such material, if truly obscene, is not protected by the First Amendment. And Chief Justice Burger presented the Miller test, which required that material must meet all 3 of the following conditions to be deemed obscene and thus unprotected. The first is whether the average person applying contemporary community standards would find that the work taken as a whole appeals to the prurient interest. And prurient interest refers to a shameful or morbid interest in sex, not just a normal, healthy interest, okay? And contemporary community standards allows for variation across different communities. Like what might be obscene in a small rural town might not be in a large city, okay? Number 2 is whether the works depict or describes in a patently offensive way sexual conduct that is specifically defined by the applicable state law. So this prong requires that the type of offensive sexual conduct that's depicted has to clearly be defined by the state statute, thus avoiding any kind of like vague prohibition. And then last is whether or not the work taken as a whole, whether it lacks serious literary, artistic, political, or scientific value. And that's known as the LAPS test. L for literary, A for artistic, P for political, S for scientific, again called the LAPS test. And if the material has any serious value in any of those areas, even if it's offensive and appeals to the prurient interest, it is not obscene and is constitutionally protected. And this is judged by a national standard, not just community standards. So this Miller test, it aimed to provide a more concrete and workable definition of obscenity than previous tests. So by introducing these contemporary community standards for the first 2 prongs and then requiring state laws to specifically define prohibited conduct, it gave states more leeway to regulate obscenity. Okay. Now, by also requiring that total lack of serious lapse value that was judged by a national standards, it still would ensure that material with any kind of genuine merit, even if sexually explicit, remained protected. So despite Miller, the obscenity remains a challenging area of law because, again, it is a subjective nature of standards. Now let's look at some examples. So for material to be legally obscene and thus unprotected, again, it has to meet all 3 prongs. It appeals to the prurient interest, applying those contemporary standards, again, meaning it tends to excite lustful thoughts, appealing to a shameful or morbid interest in sex. It is patentably offensive. And again, applying those contemporary community standards, like it depicts or describes in a clearly offensive way the sexual conduct that is specifically defined by the applicable state law. And then it has the lapse value. It lacks serious literary, artistic, political, or scientific value. Again, applying a national reasonable person standard. So let's say that you have a highly graphic film that depicts extreme and non consensual sexual acts, explicitly designed to appeal to voyeuristic sexual urges. That film is distributed in a community where local standards would find those depictions as very offensive. And it had no discernible plot or character development or educational, message. This could be deemed obscene under the Miller test. It likely appeals to prurient interest and is definitely offensive according to community standards. But the key question is whether it would be does it possess any serious literary, artistic, political, or scientific value? If it is purely gratuitous and exploited, then it's lacking any redeeming artistic, or communicative merit, then it's going to likely fail that lapse test and be deemed unprotected as obscenity. Now, let's say that you have a critically acclaimed art film from Europe that contains, explicit sexual scenes, but those scenes are integral to the plot and character development and, artistic expression of the film, exploring themes basically of like human relationships and vulnerability, and it is shown in an art house cinema. And this film might appeal to the prurient interest for some, and it could be considered very offensive by certain community standards. And it is likely to possess, much to the chagrin of many, the serious literary, artistic, political, or scientific value. And because it meets that lapse prong, it would not be considered legally obscene under Miller and would be protected by the First Amendment despite its explicit content. The context of its creation, the distribution, and the critical reception would be very important parts to explore. Now, let's say we have a stand-up comedian who uses vulgar language and, sexually explicit jokes that many audience members find offensive. This is some people may find it, patently offensive or appealing to the prurient interest, but comedy, even the raunchiest comedy, is still a form of artistic expression. And unless the performance completely lacks any serious artistic or political value, which is a high bar for a comedic performance, it would not be considered obscene under Miller, and it would be protected. Because, again, the Miller test is designed for hardcore pornography, not, generally offensive or vulgar speech. And speaking of pornography, closely related to obscenity, but treated even more harshly due to the profound harm involved in this, is child pornography. And it's a category of speech that is categorically unprotected by the First Amendment, regardless of whether it meets the Miller test for obscenity or not. And the definitive case here is New York versus Ferber. So Paul Ferber was a bookstore owner who was convicted under the New York statute that prohibited the knowing promotion of, child sexual performances. And the statute did not require that the material be obscene under the Miller test, simply that it depicted sexual conduct by children. And Ferber argued that this law violated his First Amendment because it did not meet the Miller test for obscenity. So the issue before the court was, can a state consistent with the First Amendment criminalize the promotion of child sexual performances, regardless of whether the material meets the Miller test for obscenity? And the Supreme Court held, yes, they can. They can ban the knowing production and distribution of child pornography, even if the material does not meet the Miller strict test when it comes to standards for obscenity. And it created a new categorical exception for the First Amendment protection when it comes to child pornography. And Justice Byron White wrote for the majority and said that the court reasoned that the overriding compelling state interest in protecting children from sexual exploitation justified this categorical ban. Okay. So unlike obscenity, where the harm is primarily to the viewer or to societal morality, Okay. The harm in child pornography is directly inflicted on the child victims involved in the production. So the court emphasized that the harm to the children occurs at the production stage, regardless of the content's, artistic or literary merit. So therefore, the strict standards for obscenity were deemed irrelevant. And the state's interest in eradicating child sexual abuse was considered paramount, and it was overriding any expressive value that the material might otherwise have. And the court declared that a state's interest in safeguarding children is of the highest order. And it is the state's interest which may justify the criminalization of sexual exploitation of children. So, New York versus Ferber, it created a clear and broad rule that child pornography is unprotected speech, regardless of whether it meets the Miller obscenity test. So, this decision, it reflects the court's deep concern for protecting vulnerable individuals and its willingness to create exceptions to free speech protection when such a compelling interest is present. And this is one of the clearest and least contested areas of protected speech. And while this area of speech is not challenged very much, I do want to give you a few examples just because we have some growing changes in society that we need to talk about. But again, this category of speech, again, it's considered outside of the protection of the First Amendment, regardless of whether it meets that Miller test for obscenity, because again, the compelling government interest is for protecting children from sexual exploitation. So if you have a video that's depicting, say, a 7-year-old engaged in sexually explicit acts, that is unequivocally child pornography, right? It does not matter if someone argues that it has artistic value, that it is not patently offensive in some context. It's just the mere depiction of sexual conduct by children, or even depictions that appear to be children. It is sufficient to render it unprotected speech. So the focus is on the harm of the child, victim in the actual production. And I know you're probably going, where is she going with this? How can she come up with other examples? But let's say that you have computer generated images or CGI or animated depictions that appear to show child sexual abuse, even if no real child was harmed in their creation. And this is a more complex area that the Supreme Court has addressed. So while the original Ferber rationale focused on the actual exploitation of children in production, courts have struggled with whether virtual child pornography should also be categorically unprotected. And generally, laws criminalizing virtual child pornography have faced First Amendment challenges, with some of them being struck down as overbroad if they don't involve actual exploitation of real children. Okay. However, and more narrowly tailored laws that focus on the appearance of child abuse or the intent to traffic such material have sometimes been upheld, reflecting that ongoing societal interest in preventing the abuse and the exploitation of children. Again, whether real or perceived. But this area highlights that evolving challenge of kind of applying these doctrines in the digital age. Now, I'm going to give you one more. And that is photographs of seemingly nude children in a purely documentary or artistic style, like a photojournalism piece on indigenous tribes where children are unclothed as part of their culture, or historical, like artistic depictions of nude children that are not sexual. And this type of material typically would not be considered child pornography. And the key is the depiction of sexual conduct and the intent to exploit. So if the images are clearly not sexual in nature and they don't depict any kind of sexual conduct, then they fall outside of the category of child pornography. The intent and the context are going to be what's crucial for distinguishing protected artistic or journalistic expression from any kind of illegal child exploitation material. So another category of speech that receives less protection than the fully protected political speech is commercial speech. And this generally refers to speech that proposes a commercial transaction, such as advertising or marketing, or even when someone is trying to solicit, a consumer to buy or sell goods and services. So, why does commercial speech receive less protection? In this case, the court has a few different rationales. Okay. One is it's more verifiable. So, commercial speech often makes factual claims about products or services, which are easier to verify than, say, someone's political opinion. Okay. This means there's less concern that suppressing false commercial speech will, quote unquote, chill valuable, truthful speech. Okay. Um, it's also less central to the democratic self governance. So, while it is important to the economy, commercial speech is generally viewed as less essential to the core values of democratic deliberation and political discourse than pure political speech. And for a long time, commercial speech received virtually no First Amendment protection. But that changed significantly with the case of the Virginia State Board of Pharmacy versus the Virginia Citizens Consumer Council. Now, this was a case about a Virginia statute that prohibited pharmacists from advertising the prices of their prescription drugs. And the Virginia Citizens Consumer Council, which was a consumer group, they challenged the law, arguing that it violated the First Amendment because it prevented consumers from receiving important price information, and it made it difficult to shop for the cheapest drugs. So the issue before the court was, did a state statute prohibit pharmacists from advertising the prices of prescription drugs? Like, did it violate their First Amendment protections for free speech? And the Supreme Court said that the Virginia statute was unconstitutional. So for the first time, the court explicitly ruled that a truthful commercial speech concerning lawful activity receives some First Amendment protection. And Justice Harry Blackmun wrote for the majority and said that, the court recognized that while the immediate interest of the advertiser might be purely economic, the information itself conveyed by commercial speech, like the drug prices, is of significant interest to the public, particularly consumers. And it is essential to an informed economic marketplace. It basically held that the commercial speech should not be entirely outside of the First Amendment scope. Okay. Now, the court did also not acknowledge that commercial speech may be different from other forms of speech, and it may be subject to different degrees of regulation. And it noted that the government has a legitimate interest in preventing false or misleading commercial speech, and that advertising is more easily verifiable than other forms of speech. It did not establish a specific test, so to speak, but just indicated that truthful commercial speech for lawful activities did warrant protection. So the Virginia State Board of Pharmacy case was a landmark decision that did extend the First Amendment protection to commercial speech because it recognized its value in informing consumers and facilitating economic activity. Now, it signaled, though, that this protection would not be as strong or powerful as that for political speech, which set the stage for a more specific test, which came 4 years later. And that specific test, which is the current standard for regulating commercial speech, is the Central Hudson test. And that came from Central Hudson Gas and Electric Corp versus the Public Service Commission. So the New York Public Service Commission was in the midst of an energy crisis, and they issued a regulation that completely banned promotional advertising by electric utilities, which were ads encouraging consumers to use more electricity. So Central Hudson Gas and Electric challenged this ban, arguing it violated its First Amendment right to free speech. And so the issue before the court was, did this state regulation that completely banned any kind of promotional advertising by an electric utility violate the First Amendment's protection of commercial speech? And the Supreme Court held that this ban was unconstitutional because it was broader than necessary to achieve that state interest. And in doing so, the court established a specific 4-part test for determining the constitutionality of government regulations on commercial speech. Justice Lewis Powell was the one who wrote for the majority and said the court outlined this central Hudson test for commercial speech. So first they ask, is commercial speech lawful and not misleading? If the speech is unlawful or inherently misleading or deceptive, it's going to receive no First Amendment protection whatsoever. The inquiry will end there. Okay, government can ban it, period. Next was, is the asserted governmental interest substantial? So the government has to show a significant and legitimate reason for its regulation. And in Central Hudson, the state's interest in energy conservation was deemed substantial. Now, next is, does the regulation directly advance the governmental interest? Okay. And the regulation has to make it so that progress toward achieving the government's stated substantial interest is possible. Okay. So here, banning the promotional advertising would indeed advance that energy conservation. And then fourth is that regulation not more extensive than it is necessary to serve that interest? And this is also called the reasonable fit, or that narrow tailoring prong, but it's not as strict as the least restrictive means that's required for fully protected speech. So the government doesn't have to choose the absolute least restrictive means, but the regulation has to be proportionate to the interest. And in Central Hudson, the court found the complete ban on advertising was just too broad. It covered even efficient uses of electricity, right? So less restrictive alternatives like requiring disclosures or banning only certain types of ads, those were available. So this full ban was considered unconstitutional. So the Central Hudson test became the primary framework for analyzing commercial speech regulations. And it allows for a degree of regulation of commercial speech that would be unconstitutional for political speech. So while it provides some protection, it also gives the government more leeway to regulate that advertising and marketing, and particularly if it is false or misleading, or if it advances a substantial government interest in a reasonably tailored way. All right. So this is the test that is still frequently applied today in cases involving things like advertising restrictions for, say, tobacco or alcohol or even pharmaceuticals. Now, I want to give you some examples. So remember, the Central Hudson test, 4 parts, okay? It has to meet all 4. So is the commercial speech lawful and not misleading? Is the asserted governmental interest substantial? Does that regulation directly advance the governmental interest? And is the regulation not more extensive than necessary to serve that interest? So again, has to meet all 4. So let's say that you have a state legislature that passes a law that prohibits all outdoor billboard advertising for tobacco products within 1,000 feet of schools and playgrounds. And the state's stated purpose is to reduce underage smoking and protect public health, right? So tobacco companies challenge the law as a violation of their First Amendment rights. So in this particular case, we have to apply the Central Hudson test, in order to determine if the state law banning this particular advertising outside or near the schools and playgrounds, does it violate the First Amendment? So again, first prong, is the speech lawful and not misleading? Well, yes, because advertising for legal tobacco products, assuming it's not false or deceptive, is going to be considered lawful and not misleading. So it's going to pass that first prong, and it's going to get some protection. Then you have to ask, is the asserted governmental interest substantial? In this case, yes. The state's interest in reducing underage smoking and protecting public health is considered widely recognized as substantial. Does that regulation directly advance the governmental interest? So the state would have to present that restricting outdoor advertising is going to reduce youth exposure to tobacco marking, which in turn would have to help reduce underage smoking. And that connection would generally be accepted as a direct advancement. Now, last is the regulation not more extensive than is necessary? And again, this is going to be your trickiest prong, okay? And in this one, the state would argue that limiting the advertising only near places frequented by children is a narrowly tailored approach. It's not a complete ban on all tobacco advertising, okay? So it's going to leave other channels open, like adult publications, adult only venues, things like that. So if the ban were for all outdoor advertising, it would likely fail the prong for being too extensive. So in this case, such a targeted ban would likely be upheld as constitutional because it generally satisfies all four prongs of the Central Hudson test. So the government has a strong interest, and regulation here is the regulation is designed to address a specific harm, which is youth smoking, without completely stifling all communication about a legal product. Now, let's say you have a state who has just passed a legalized casino gambling law, but they pass a law that prohibits all form of advertising for those casinos, okay? And the state argues that this ban is necessary to prevent problem gambling and to protect citizens from its social harms. Believing that advertising, is inherently going to encourage excessive gambling. And casino operators challenge the advertising ban. So again, we have to do the Central Hudson test to determine, does this violate the First Amendment protection? So is the speech lawful and not misleading? Yes. Okay. Advertising for a legal casino gambling company is, assuming it's not, misleading, is going to pass the prong, assuming that it's truthful and lawful. Now, is the asserted governmental interest substantial? Well, sure. Okay. Because preventing problem gambling and protecting citizens from, social harms is generally considered a substantial governmental interest. All right. So does the regulation directly advance the governmental interest? And the state here would argue that a total ban on advertising directly reduces exposure to gambling promotion, thereby reducing instances of problem gambling. And this could be seen as directly advancing the interest. But for the sake of argument, let's just say that it does, right? So we go to the fourth prong. Is the regulation not more extensive than necessary? And this is where that ban would likely fail, because a total ban on advertising for a legal activity is usually seen as more extensive than necessary. And the state could likely achieve its interest through less restrictive means, such as banning deceptive or misleading gambling ads, or prohibiting advertising to minors, or requiring warnings about the risk of gambling, or restricting advertising to certain times or places, like late night TV only, things like that. So again, the likely outcome here is that a complete ban, again, for advertising a legal activity would likely be struck down as unconstitutional, because again, it's more extensive than necessary. The government could absolutely achieve its substantial interest through less restrictive means. So let's say that you have a state bar association who implements a rule that prohibits lawyers from using testimonials from former clients in their advertisements, even if the testimonials are truthful, okay? The Bar Association argues that this rule is necessary. It is necessary to prevent public deception and to maintain the dignity and professionalism of the legal profession. Okay. So a lawyer who wants to use truthful client testimonials challenges the rule. All right. So we got to put it through that Central Hudson test. Is the speech lawful and not misleading? Well, the lawyer claims the testimonials are truthful and not misleading. So if proven true, this prong will be met. And this is going to be a factual hurdle for that lawyer to clear, okay? Now, next is the asserted governmental interest substantial? And the state's interest in preventing public deception and maintaining the professional standards, especially within the legal field is generally going to be considered substantial. Now, does that regulation directly advance the governmental interest? And the Bar Association might argue that testimonials, even if they are true, they can be inherently misleading because a client's specific experience might not be representative. Okay. This could be seen as directly advancing the goal of preventing deception. So we're at that last prong. Is this regulation not more extensive than is necessary? And again, this is our sticking point usually. Is a total ban on all truthful testimonials the only way to prevent deception? And the answer is probably not. Okay. The state could likely achieve its interest through less restrictive means, like having a disclaimer on there about, results not being typical, or mandating some sort of disclosure of client context, or prohibiting only testimonials that are going to make a specific verifiable claim about an outcome, like I won $1 million, that type of thing. Okay. So a complete ban on truthful client testimonials would likely be struck down, again, because it's more extensive than necessary. So the state has a substantial interest in preventing deception, but a total ban on truthful information is usually overbroad when there are less restrictive alternatives that exist. And reflects the court's general skepticism of bans when it comes to truthful commercial speech. So beyond the categories that we've discussed in detail, like incitement, fighting words, obscenity, child pornography, and commercial speech, the Supreme Court has identified a few other types of speech that receive less or no First Amendment protection. So let's talk about those briefly. And some may end up coming up again, but we're just going to kind of touch on these. So let's talk defamation. This involves false statements of fact that harm someone's reputation. So while the First Amendment generally protects speech, it does not protect knowingly false statements that injure somebody's reputation. Now, for public figures or public officials, the bar to prove defamation is very high, and it actually requires proof of actual malice. And that means that there is knowledge that the statement was false or a reckless disregard for the truth. And that's going to protect public debate about public figures. Let's walk through some examples. So you have, say, a disgruntled former employee who spreads, a false rumor online that their previous boss embezzled money for the company. Well, if the boss's reputation is harmed and the statement can be proven false and negligently made, then this could be defamation. One thing to note here is when it comes to reputational harm, this is the part that's usually difficult for people to prove. And it's easier if there's something like, oh, I lost a contract, or I got fired, things like that. That's easier to prove than some of the other stuff. Now, let's say that you have a celebrity magazine that publishes an article falsely claiming a famous actress is a drug addict. So to win a defamation lawsuit, the actress, who's a public figure, would not only have to prove that the statement was false and harmed her reputation, but also that the magazine published it with actual malice, meaning that they knew it was false and or acted with reckless disregard for the truth. And that would be, that they had strong evidence it was false, but published it anyway. Now, let's say that a local newspaper prints a false story alleging that the mayor took bribes from a developer. So for the mayor to win a defamation suit, he would have to prove the actual malice on the part of the newspaper. Again, demonstrating that they knew that this bribery claim was false or recklessly disregarded whether or not it was true. Now let's shift to true threats. This is a serious expression of intent to commit an unlawful act of violence to a particular individual or a group of individuals. And these are not protected by the First Amendment because they instill fear and are often a prelude to violence. So the key here is going to be distinguishing a true threat from political rhetoric or mere hyperbole. For example, let's say that there's a heated protest and an individual yells to a specific public official, I'm going to find where you live and kill you. That could be considered a true threat if, based on the context, a reasonable person would interpret it as a serious expression of intent to commit that violence. Again, rather than just a hyperbolic statement. Let's say that you have an anonymous online post on social media and it states, I will bring a gun to the school on Friday and shoot everyone who wronged me. Even if anonymous, if this is perceived as a serious and credible declaration of intent to commit violence against a group, it's going to be considered a true threat. Let's say you have a disgruntled former employee who sends an email to their ex-boss and it says, you'll regret what you did to me. I know where you drive home every day and your car, it will explode. Again, that could be interpreted as a true threat due to its very specific and violent nature. Next, we have perjury and fraud. So speech that constitutes perjury, which is lying under oath, or fraud, which is making false representations to obtain some sort of unfair advantage, receives no First Amendment protection. These involve knowing falsehoods that are designed to deceive and to cause harm, which undermines the integrity of the legal and commercial systems. For example, a witness in a court trial swears to tell the truth, but then knowingly gives false testimony under oath about an event that they witnessed, intending to deceive the court. That is perjury. Let's say that you have a salesperson who knowingly makes false claims about the safety features of a car and they're being made to induce a customer to buy it, knowing that the car actually lacks those features. That constitutes fraudulent speech. Now, let's say that you have an individual who knowingly provides false information about their income and assets on a loan application to qualify for a loan that they wouldn't otherwise receive. That is a form of fraud. Now, this is our last category, but this is speech that's integral to criminal conduct. And that is speech that is directly linked to and it forms an essential part of criminal conduct, and it receives no protection. So, for instance, like soliciting someone to commit a crime or conspiring to commit a crime, that is not going to be protected speech. So, for example, one person calls another and offers them a specific amount of money to assault a third person. The act of making that offer, even if purely verbal, is speech that is integral to criminal conduct. It is solicitation to commit assault. Let's say that you have two individuals. They're talking back and forth. They're planning details of how they're going to break into a store, right? Their verbal exchanges that are mapping out the crime are integral to what would be considered a criminal conspiracy. Or let's say that someone gives detailed instructions to another person on how to, construct an illegal explosive device, knowing that the person intends to use it to commit a crime. This speech is providing instructions. It's integral to the criminal act, which would be aiding and abetting. And that's pretty much it. This is just the first part of our exploration of the freedom of speech. Next week, we're going to talk about symbolic speech and the public forum doctrine, where speech can take place, and speech in special contexts like schools, allowing us to build on these foundational principles. So if you have any questions, make sure to reach out. Bye.